uh, uh, which we wanted to deliberate, is criminal liability of KMPs under Companies Act. So when I say KMP, this also includes the directors under the Companies Act. So as a company secretary of many company as in KMP, and also we have been covered under the KMP, and with this right and power, it also comes with a liability also. So today, we are going to deliberate various liabilities of KMP under Companies Act. And this time, we have a Poonam Pokiya from our office. Poonam is our manager, a company secretary with around 7 to 8 years of experience. And she is part of our secretarial team. And of course, Mr. Bala, he doesn't require introductions, a very seasoned profession with more than 40 years of experience in this corporate world. And now he's a regular writer in the he writes various articles in the legal magazines. And we are also very fortunate to have our today's guest speaker, Mr. Pravin Sarawat. Sorry, by profession, he's a chartered accountant and also company secretary. He has done his DISA also. And he's also insolvency professional. So the learning is never stopped for him. So practicing as a chartered accountant since 1987 under the Saraswat and company located at Jaipur, and it's a firm with 5 partners, and he has a lot of interest in the taxations like direct taxation, indirect tax, company law, and mercantile law. So, and he has written an article on this criminal liabilities of KMPs and directors under the Companies Act. So probably we have one of the learned speaker. So yeah, over to Mr. Bala. You can just speak.
Good morning to all of you. I have a great pleasure in welcoming you for today's seminar, which is very, very interesting topic to all of us. When you are taking the liabilities, yes, liabilities are there along with the responsibility and role and duties. But when the liability comes, it is actually distinguished in 2 different categories. One is the civil liability, one is the criminal liability. As we are all learned in the beginning when we started our company secretary course, the very first thing is we started learning interpretation of act and also gone through the various acts. 2 important acts I would recall is actually civil procedure code and the criminal procedure code. What is criminal, what is civil? That makes the difference when you talk about the liability. Civil is the one where mistake happens inadvertently, missed out, without any intention. We are willing to rectify, we are willing to do it, everything. That is where the civil nature comes, where it ends up with fine and penalty. When it's come to the criminal nature means it is actually pre-planned with a guilty mind. It is definitely to cheat somebody, to mislead somebody, to definitely do some harm, injure some properties, etc. It is pre-planned. If it is a pre-planned with the mind, guilty mind, what we call it a legal term, mensory, if that is present, then it is actually a criminal liability. There are various sections in the Companies Act which talk about the criminal liability. Some of the sections very recently has been actually decriminalized also. But however, where the criminal liabilities comes, because as we know, directors are nothing but trustees of the shareholders of the company, because they hold everything on behalf of the shareholders and they work as per the power delegated to them under the article of association of the company. The question is, are they exercising the power within the given power to them? Are they exceeding the power? If they are exceeding the power, so that means they are acting over and above the power which is given knowingly. In which case, there are many issues where the personal liability also comes on them on that. And second thing is again committing fraud. Separately discussed in the Companies Act, the fraud has been designed, the fraud has been actually defined. I think our presenter will explain to you on fraud. Third thing is that misleading the people, especially the investors or shareholders, and inducing him to take decision, giving the misinformation with a modified intention. So these are all the cases where definitely the criminal things are involved. The criminal liability actually arises. Because basically what happens if we actually go through the Companies Act, it talks about a couple of things. One thing is that directors are bound to be with their fiduciary duties. So they have the fiduciary relationship. So that means they cannot do anything breach of their fiduciary relationship. They should act. Any breach of fiduciary will definitely attract a criminal liability. Second thing is acting in excess of the power, which is actually known as the ultra vires. The third thing is that negligence has been actually brought because they are supposed to exercise their due diligence and skill in the best judgment to do all the good for the people in larger good. If that is also absent, then that will also attract criminal liability. Then, of course, the bona fide intention is there. So these are all the things which has to be present when you establish the criminal liability. So this is where we actually come into. There are various sections when we are talking about the prospectors and the company make the prospectors, the director who are responsible. They are supposed to give the right information. If they give the misleading information, if they give the incorrect information, if they induce the investors by producing the wrong information, then definitely it is a criminal liability. Then again, we have seen very recently there are various fraudulent trading which is taking place. The company stocks are unnecessarily manipulated, going down, up and down. People make enormous profit, gain, or whatever it is, etc. Those cases also will come into picture. Of course, there is a statutory duties which has been laid out in the various sections of the Companies Act, where we talk about what are the various provisions, what are the compliances which they are supposed to do it. In the various statutory duties, the failure to do the statutory duties, as I said very clearly, if it happens inadvertently, if it has happened by mistake, if it has happened without any intention, then that is a civil nature, which is actually definitely attracts a fine and penalty. Normally, everything is a penalty if that is the case. And there are ways and means of sorting out the penalty because the law proceeds. Okay, you pay the fine, or if there is a thing, you compound the offences, get over the things, etc., which also our president is going to talk about. Question will arise: okay, all said and done, criminal liability is there. How do the directors safeguard themselves from the criminal liability? How do they ensure? That is the crux of the matter. Because there is various safeguards which are actually available. Because as you are aware, we have the two sets of people. One is the executive director, other is the non-executive director. Executive directors are involved day-to-day affairs of the company. They are involved day-to-day operations of the company. They oversee what is happening. Non-executive directors, they actually periodically visits. They participate what we call the board processes, and they share their view. They guide the company. They lay down the policy, procedure, etc. Another thing and all. They are not involved per se on day-to-day operations. So that makes the difference between the executive director and non-executive director. So the executive director liability is much more than the non-executive director when it comes and involved day-to-day affairs of the matter. For a small example, in the case of the Negotiable Instrument Act under Section 138 of the Act, check bounce, which has been actually mentioned in our Companies Act also, because they being a authorized people like a KMP, action can be taken against them. Specifically, the Negotiable Instrument Acts talk about officer, company secretary, etc. So here, can the non-executive director has been brought under the check bouncing case as a criminal liability? Obviously, they cannot because they are not involved day-to-day affairs. It is only the people who are involved day-to-day affairs. That is the difference which makes actually. So it is a very, very interesting topic. There are a lot of case laws has been there. So as we go along, we can actually see. As Pravin is there with us, who's actually written articles on this matter and he is having a practical experience, I would pass on the mic over to him. I will ask him to share something on this particular topic and his views on that before we start. Over to Pravin, please.
Thank you. KMPs play a pivot role in the management of the company, and the directors and KMPs attract criminal liability under the Companies Act by virtue of the statutory liabilities under different sections, and they also face the vicarious liability by virtue of other statutes. I would like to define this. Corporate criminal liability can be defined as a crime which has been committed by individual or association of individual who, for pursuing a common purpose or make business gain, in course of their occupation commit such acts or omission which is forbidden by law and with the guilty mind, whether it is for the benefit of the corporation or any individual or the association of individuals. This is the broad definition of the criminal act which can attack the liabilities. And again, the liability depends on the role one plays in the affairs of the company and not designation or status. A person not holding any office or designation in the company, or maybe there may not be any KMP designated in a company, would still be liable if he satisfies the main requirement of being in charge of and responsible for the conduct of business of a company at the relevant time. That is the main point where the criminal liability arises. And again, at the same time, there are various statutes. They don't recognize the difference between the executive and the non-executive director, and thereby subjecting all class of directors and the KMPs to the same liability. Bala sir has given the example of Negotiable Instrument Act, where these directors and other people are facing the music day and night. And rather the government should come out with a solution to this problem by this. Either they can insert a clause in the Companies Act itself that this provision would override all other statutes, so that the directors and the KMPs work without any fear of vicarious liabilities under the other statutes. At the same time, KMPs have the protection against the criminal liabilities. I think I would like to touch upon this subject at the end of this presentation by Poonam, because that would be, first of all, it would be better if we know what kind of the criminal liabilities these KMPs can attack under the Companies Act. And thereafter, I would like to give my inputs how to protect one from the criminal liability and working without fear. Back to Balaji.
Yeah.
I think we can start the presentation.
Yeah, Poonam, we can start.
Yeah, Poonam.
Yeah. Good morning, everyone. As the sir has already thrown some light on the criminal liabilities. Now let's begin. Now first, see what is crime. So every act which is done by the individual is not act as which is not said as a crime, but an act is a crime only if a state or the federal government defines it as one. So there are crimes are classified as either serious crimes or comparatively less serious crimes. The next one is the fine versus the penalty. So fine is referred to as a sum of money ordered by the court to pay for an offense done by the individual, whereas the penalty do not involve the court proceedings. The individual is charged with the penalty for not comply with the provisions of a specified act.
1 minute. No, sir. I just wanted to just go to the previous slide. I think many of our members, they still do not understand, the difference between the fine and the penalty. So the fine, where the court, levies. So the fine is been levied by the court, and the penalty is been levied by any quasi-judicial authority. So in case of a fine where court orders, that so and so has to pay X amount of fine, something like this, right, Mr. Bala? I mean,
yeah, absolutely right. Absolutely right.
So now this, I think, and particularly, sir, we have this insolvency and bankruptcy, where this penalty and fine, been sometimes not been used correctly. So of course, now it is getting amended. But yeah, Mr. Pravin, your views on this, fine and penalty, because many of the members, including chartered accountant and company secretary, they overlap, So the fine is one which is levied by the court. Yeah,
it's okay, sir.
Yeah,
Go ahead.
Yeah. The next one is the criminal liability versus the civil liability. As Bala sir already explained about what is civil and criminal liability. So let's discuss in detail. The civil liability is the legal obligation in which the court orders to pay compensation or follow the duty. Whereas in the criminal liability is attract when the person performs any forbidden act for which he or she can go behind the bar. Civil liability arises when there is a civil offense, where criminal liability arises when there is a criminal offense. civil liability, under the civil liability, the code of civil procedure law is followed, whereas under criminal liability, the code of criminal procedure law will be followed. Under the civil liability, the remedy available to the person is compensation or to pay the duty to perform something, whereas under the criminal liability, person has to pay the fine or penalty, fine or imprisonment, fine and imprisonment. So in the criminal liability, the person can be punished with the imprisonment. Under the civil liability, aggrieved party will prosecution was initiated by the aggrieved party, whereas under the criminal liability, it will be punished by the government.
Give you a small example. The same act, depending upon the nature how it is committed, it can be classified either as civil or criminal. Act may be the same in both the circumstances. But what is the circumstances? Let us look at it. I am living in a flat. I am living in a bungalow where I have a very good garden. My neighbor is there nearby. He is also having a adjacent bungalow. There is a common one is there. He is also having a very good garden. Somehow other, my neighbor feels very jealous on me because I made him a very good garden, etc. and all these things. He thinks I will destroy his garden. He does something. He unnecessarily, release plenty of waters and he ensures all my plants and things, etc. suffer with the excessive water and other thing and all. He causes a heavy damage and actually make the loss to me. So here, what he is doing is he is actually planning the activity. He wanted to make my garden to be destroyed. That is his intention. He wants to commit damage to me. So naturally, this applies the criminal offense. But whereas, let us look at the same case. Suppose my neighbor is actually going out for 4 or 5 days. Suppose there is a mistake. He opened one of the tap inside on a bathroom or kitchen or whatever it is. He left it open and he went back. So water start coming out. It actually come down in my place, etc. and all this thing. Obviously, water is going on and all. Then we actually discover. Then we contact him. Then he said, "Oh, I'm sorry. I think I made a mistake or something. I got the key here. Why don't you open? Why don't you check, etc." I will do that. That's what he says. He comes and it is stopped. Action is taken. He comes back. He comes to you very apologetical face. He says, "Very sorry. In a hurry, I did not do this thing. I'm very sorry about it. Another thing and all. What has happened? I am willing to actually, rectify whatever the things are there." He comes. Many times the serious nature is there. We say, forget about it. Otherwise, okay, that is one. The act is the same in both the cases. But what happens? One is committed with the intention to cause damage, intention to make me to suffer deliberately, other is happen accidentally. So the same act can be a civil and criminal. Here also, how it is committed, what is the state of mind, whether it is done with a guilty mind, whether it is happened accidentally, that makes the difference between the civil and criminal.
So now the Companies Act 2030 has introduced some terms like fraud. So the company, as per the Companies Act, if a person in relation to the affairs of a company or body corporate includes any act, omission, concealment of any act is committed by the person or any person with the intent to deceive or gain undue advantage from the company or the shareholder or the creditors or any other person with whether or not there is any wrongful gain or loss. So it is termed as a fraud, which will be punished by the act. Now, what is the meaning of the wrongful gain? It means the gain by the unlawful means of the property which is not legally entitled to that person. Wrongful loss means a loss by the unlawful means of a property which he is not belonging to.
So here, if you see here, very clearly, lawmakers made it very, very clear. Intent to deceive. That shows the guilty mind, what he is actually planning. Gain undue advantage. These are all the two things which has to be present when we are examining whether it is a fraud or otherwise. Yeah, go ahead.
The next is the false evidence. So if the person is legally bound by an oath or an express provisions of the law to state the truth, to make a declaration, and he makes any statement which is false, which he knows that and believes that it is false, then it is termed as false evidence. Then false statement. If a person makes a statement which is false in any material particulars and omits any material act which he knows it is to be false and it is not immaterial, then it is said as a false statement. The next is who is considered responsible for this. So in case of a child, if their parents and guardians are considered as responsible, so similarly in the case of a company, the person who in charge of the responsible, who is in charge or responsible for conducting the business at the time of committing that offense, like directors along with the KMP shall be responsible for the act. The Companies Act defined what is the officers in default under section 260. The officer in default includes the whole-time director, KMPs. When there is no KMP, then such director is specified by the board who has given their consent in writing to the board, or any other person who under the immediate authority of the board or KMP who is in charge of that responsibility. Any person in whose advice, directions or instructions the board of the company is accustomed to act. Every director who is aware of such contravention by virtue of the receipt by him of any proceedings of the board or participation in such proceedings. And in case of the issue or transfer of any shares, the share transfer agent, registered merchant bankers to the issue of the transfer shall be held liable. So, and what is KMP? It is defined under section 251, which includes the CFO, managing director, manager, company secretary, whole-time director, CFO, any such person, officer who is designated as a KMP by the board.
So
Now,
our number is 2, company secretary is the Bakara number 2. So the Bakara number 1 is the, just go to the previous slides. So yeah, so you have a CEO and the managing directors and a manager, and a company secretary, the whole-time directors and the CFO. Sir, what is happening nowadays, the SEBI particularly, they are making company secretaries and CFO liable, personally liable. Now, this is a new trend which is happening, after this new LODR regulation has come. Sir, there are already a decided case where, where the SEBI has not only penalized the company, their promoters, and nowadays, it is all, even a company secretary, employee company secretaries have been fined. And these are very frequent in case of insider trading, where the company secretary was responsible to take care of those insider tradings. So yeah, this is the new trend which is happening, and that is why the many of our members are very scared. And I know a couple of company secretaries, they are not leaving the company because they say, Mr. Mehta, let them pay my penalty first. And then I think you have a recent case of a PVR insider trading case where 6 lakhs been imposed on a CEO also, and separately to a company secretary and a compliance officer also. So now this is, as I said, this is a very regular trend and a new trend which is happening in the corporate world.
Not only that, in fact, very recently I came across in one of the case where the CSR contribution on an unspent amount was to be actually transferred. The company was to spend about 2.89 crores on CSR activities. They had actually spent only 2.83 crores, so balance 6 crores money was to be actually transferred to the CSR fund at the end of the year within 30 days time or something. In fact, what they have done is they have actually transferred somewhere in the April itself. But unfortunately, the money has actually bounced back. It did not get credited in the government account. Company, nobody has noticed. And they noticed only at the end of the year. Only at the end of the year, when they have noticed, they have transferred the money to the unspent amount of the CSR, the specified fund. Now the regulator has come very heavily on them, and they issued the show cause notice and other thing, and they try to explain everything. Whatever it is, there is an offense because which you are supposed to do, which you have not done it. Even if the bonds were, you would have taken the rectification action. So what they have done, they have imposed double the amount of the fine on the company, 1/10 of the amount. That means around 55 lakh rupees or something like that. Each of the director, as well as the company secretary and also CFO, as you rightly said, they are not to pay this money from out of their own pocket. This is what the judgment has done.
Sir, I'll just read out one. I'm just seeing one case where in case of Urja Global. Yeah. Now this is a very recent last week decision by SEBI, where SEBI imposes rupees 1 lakh penalty on a company secretary of course, now it is public, so I can take a name also, Kanika Arora. Case, where while passing this order, I'm just reading this order, which says, in an order of 30th September 2022, just 7 days before, Mr. Hariharan AO of SEBI says, having knowledge about entire functioning of company, the company secretary will be in the most suitable position to identify if the company is on a verge of committing any default. See this. So, so being a company secretary, they have assumed that you are in a position to understand the this default is going to happen or which hasn't happened. Accordingly, if the company secretary is of the opinion, so even the company secretary probably must have argued that the directors have failed to fulfill their fiduciary duties, and that is why that resulted into the non-compliance, where of course then the company secretary reported in the company secretary is expected to take the step in the best interest of the company. Now tomorrow you cannot say, look, my directors did not allow me to file this, that. See how things are changing, sir. I mean, so this is a very interesting case. I think one should take this separately. But it says I mean, the company secretary is in best position to identifying. I'll just read out this again. Having a knowledge about the entire functioning of the company secretary will be in the most suitable position to identify if company is on the verge of committing any default. Accordingly, if the company secretary is of the opinion that the directors have failed to fulfill their fiduciary duties, resulting into the company defaulting into the disclosure, the company secretary is expected to take the step in the best interest of the company. Anyway, this is what the judgment which has been given, and this is just last week.
You are right here, because what happens is, in any board meeting, invariably, company secretary, though he is not the board member, he is present right from the beginning till the end. He knows what is happening. He knows what is coming out. He knows what are the actions. He also equally expected to know, because you are the expert in the corporate laws. He is supposed to say what is right and what is wrong. And second thing is, Companies Act also very categorically spelled out while talking about the duties. He has to ensure that company complies with all the applicable laws to the company. So that means that the insurance of the compliance is actually entrusted upon the company secretary.
Yeah.
And as you talk about the LODR talks not only a company secretary, but they have gone one step ahead. He said, compliance officer. That is what they said. Because designation of the LODR regulation is not the company secretary. It is the compliance officer. It is only the qualified company secretary. He will be appointed as a compliance officer under the provision of the LODR regulations. So naturally, nowadays the company secretaries, the pivotal role is enormously increasing more and more. And as you rightly said, the personal liability, which used to be there earlier for only the directors, now it has dropped down to not only the company secretary, even for the chief financial officer as well. So we have to be more careful, and we have to understand the thing. We have to advise right or wrong, and wherever they are going wrong, we should actually correct. That is what it is expected now. Yeah.
So this is what, so I think Pankaj has raised the question. Does it mean that company secretary has to be always a whistleblower kind of a person? I just, Pankaj, I'll take up this, where in the similar case, see what has happened. It is an alleged that the company has been making a misleading positive corporate announcement without any intention to fulfill the same, and with the sole intention of misleading the investor. Now, it is alleged that the noticee, that is company secretary, who were the designated compliance officer and a part of the KMP of Urja Global during the examination period, have failed to carry out the proper adequate due diligence while overseeing the process of disclosure and communication in respect of the so-and-so and various other corporate announcements. So where the probably promoters has highlighted communications, or they've given a communication which is not correct, and which is exaggerated, or which is misleading to the public investors. And see, the company secretary cannot keep silent and say, look, he has to act, So, so answering to Pankaj, Desai questions, yes, probably that is what the judgment says.
Samir is actually saying here. However, there are several incidents wherein the company secretary told to get out of the board meetings. Then what happens? Because practical approach is different from the theoretical approach. You are right, Samir. It is the choice of yours. You want to work the company which is actually willing to follow the best practices, do the right thing, or you want to go along with them. If you are tolerating, if you are sailing along with them, you have to face the music. Always the choice is actually with you. You have to take a call on that. That is what I would say. Actually. Yeah, what do you say, Pravin?
Yeah, Mr. Pravin.
So actually, the fear of criminal liability amongst the professional is increasing actually. If you see the statistics of the resignation of the independent directors and the KMPs in the last 4 years, it is increasing every year. Now the professionals are realizing the risk which is associated with if they don't do the things properly, the risk which is upon them. That's why the pace of resignation is increasing. And the same is the case with this chartered accountant firms also. You might have seen the spat of the resignation when the final accounts are placed before the board. You might have read that some CFO has resigned, some company secretaries have resigned. I think the inside story is that they are not agreeing with the board, and they were ultimately thought that it is better if they leave the company.
Correct.
I think that should be the answer to the Pankajji also. If he is under some kind of compulsion or pressure, it would be better option to go elsewhere instead of working with these people.
Yeah, you are absolutely right. There's another question has actually come from Lashmikant. Whether the CS has to be there in the meeting of only independent directors, does it create a conflict of CS attendance? See, the question is, independent directors are supposed to have at least one separate meeting without anybody. That is it. What they have decided, if they actually inform, that is more than sufficient. It is not necessary CS2 is required to be attended. Law is not expecting that. Here, so it is not the question that the CS not attending the independent directors conflict. That question does not arise. Law themselves say independent director will meet separately at least once in a year. They discuss about the other thing. They will give the feedback to them. That's all. Otherwise, CS is not required to be here. Another thing is that there is a Ramana is saying we are not getting soft copies of the presentation since the last two. Okay, this you will send it. We will send it. There is no problem. This we are sharing it. We will advise you. You will get it. There's no issue. Yeah. See, the choice is actually yours. Whether you want to with the company which is actually following the right thing, or you want to sail still with the company, and because you have where do I get a job, where do I go, etc. Because of your own fear, that call you have to take. Nobody can answer this.
The next one is what are the causes, which causes the liabilities to the company, to the third party, liabilities for breach of the statutory duties, liability for act of the co-director, liability for breach of warranty, and the criminal liability. So all this liability arises due to breach of fiduciary duty, where the director acts dishonestly to the interest of the company. The next one is Ultra Virus Act, where the director breaches the powers and the activity which is defined as per the MOA and AOA of the company. The third one is negligence. The duty of the director is to safeguard the accounts and the properties of the company. If the director fails to do so, he shall be deemed negligence, and further he will be held liable for the losses and the damages caused. The next one is Malified Act. Directors are the trustees of the monies and the properties of the company. So if there is any default, they shall be liable for the breach of trust and may be required to make good the loss or the damages that suffered by the company.
There are some questions have come here. I think Tushar is saying, why can't we include a functional head? Should be treated as an officer and depart and make them liable as per the HR appointment letter. Let them also feel heat. See, here the question is, company can designate any particular person as an officer who's in charge for this. Here, you cannot simply say officer depart for everything. For example, in case of the labor laws, it is actually HR manager. He will be officer in default. In finance function, it is a chief financial officer or financial accountant. He is officer in default. In case of the company law and other matters, etc., then we are officer in default. Like that, company can identify each branch of the thing. They can designate a person who will be an officer is there. Because if you actually look at the company law procedure, what it talks when we talk about the liability, you are liable in the capacity of the officer. That means if you are in charge. In the initial slide, Poonam has actually puts in at the time of committing the offense, who was actually in charge. That is where the officer comes into the picture. Second thing is officer in default. Officer in default is the designated people, the directors and KMPs who are actually an officer who are in default because they are interested in the job. And of course, the fraud is treated separately as we have discussed. Apart from that, the personal liability comes in the picture, which normally happens if you actually exceed the powers ultraviolet. What is the current slide she has actually put in. The company law itself is recognized under this head. So designating the officer in default for a particular function, that is up to the company. They can decide they like to do that. So there cannot be a uniformity of the law, etc. and other thing at all. Second thing is there is a Rajendra is asking if the company secretary knows that the company and directors are doing something wrong and not in accordance with the law, what he can safeguard himself apart from resigning. Atul?
So I'm just laughing. I just read that case law.
Yeah.
When the promoters, were just highlighting, about the growth about the company, which was not the true.
Yeah.
So CV just, it came down very heavily on a company secretary that, see, look, you were knowing this, then why did you keep silent? So 6 lakh penalty to him also. So I think, things are changing. You can't take a shelter, and you can't be, so the best way is to resign from the company. Or otherwise, you create a documentation where tomorrow, if, anything comes up in a court where you say that, look, I have done my due diligence, But, if anything is going to the public, and particularly for a listed company, because, there the investors are involved.
Correct.
So there again, even if you create any internal documents,
it is not going to help you.
It is not going to help you also. So the trend is changing, sir. Earlier, probably 3 years before, you could have taken a stand, look, I'm like, I'm a junior, this, that. But now you cannot.
Yeah,
I cannot
right.
say I'm just a fresher company secretary, and please, excuse me.
Correct.
I think, yeah.
Tarak Shah is asking if the CS is not required to be present in the meeting of the independent director, then how to take minutes of the discussion? No, law doesn't expect years to take the minutes of the discussion. It is actually they have to keep the record, they have to keep the thing, they have to only give the feedback. They had a separate meetings, etc. On any particular point, they will inform. That note is actually sufficient as far as you are concerned. You are not to be present, you are not supposed to take the minutes, etc. and other thing at all. The whole purpose of having a separate independent directors meeting will be defeated if that is the case. In the absence of the KMP, whether express concern in writing to act as a KMP is needed by director to fix the liability. See, law itself says, if you actually go the definition section 2, it definitely very categorically says all the directors who are there, they are the KMPs of the company. The moment company secretary is actually appointed by virtue of his position, by virtue of the definition, he is a KMP. There has been actually question comes whether the private company, they are not required to appoint a KMP, whether the company secretary is KMP. The moment you appoint the company secretary, is automatically a KMP by virtue of the definition itself. So there is no question you have to separately designate as a KMP, etc. Another thing and all. By virtue of the position itself, you are a KMP actually there. Then again, Tushar is saying, in that case, function head concern from should be filed with the MCA to portal CS. Many functional head don't even know what is the law and the compliance to. See, I'll tell you one thing. In my practical experience, not today, I was working with the 1956 Act. But 1956 Act, we were working. That time, there was no compulsion that the chief financial officer is required to sign the balance sheet, etc. Other thing. But we made it a practice right from that time always the chief financial officer or financial accountant, he used to countersign the balance sheet, and thereafter the director and company secretary used to sign. In fact, what we have done is we have made him as in charge of the finance function. We have even filed DR12 form at that particular time for him. That you can actually do. Person in charge of the company business, can he be only CEO and exclude the board CFO, CS, and KBs. Yeah, here there are certain companies which are actually functioning. They are working with the designated chief executive officer, designated with the manager, although they are not the board of director, but still, even if you say CEO or manager, they are equally responsible like that of a managing director only. Because law says that he may not, but ultimately, if he is holding a overall control, he is in charge of the day-to-day operation. Whatever name you call it, whether you call it CEO, whether you call it manager, whether he is a managing director, board member or board not member, he is definitely liable. Yes, go ahead, Poonam.
See, nowadays, SEBI has also returned to many stock exchanges if the company is not following, or company is not following the LODR. So I'm just reading one case, which is, a case is Advanced Lifestyle Limited versus Bombay Stock Exchange Limited, where Bombay Stock Exchange has penalized company for not appointing a compliance officer and 2 independent directors. So now this is again a new trend which is happening. So the company was levied a penalty of 20 lakhs 40,000 rupees to be very precise. So rather they should have appointed a company secretary, instead of paying up penalties.
Yeah, in fact, what you are saying, there are n number of cases even under the Companies Act. Non-appointment of the independent director, non-appointment of the women director, non-appointment of the company secretary, all those cases also there. Not only that, even in a company, if the company secretary resigned, his vacancy is to be fulfilled within a period of 6 months. Company has actually fulfilled the appointment of the application much beyond that 6-month period. Although the company has appointed the company secretary much beyond the 6-month period, the period of intermediate period beyond the 6 months and till the date of the appointment, which remain as a non-compliances, they have been actually penalized. This is definitely there. Nowadays, the regulators are very seriously looking into all those things when it comes to the compliances.
Yeah, Poonam, we can pursue it. Yeah.
I think, in fact, you are talking about CEO issue, correct? The CEO or manager, etc., and other thing at all. Mr. Javeri Kaushik Javeri can share one of the case law very recently he has forwarded. What has happened is here the person who was really doing everything, but he was not appointed by the board member, and he was not even filed the DR12. There is no board resolution, etc. The liability has come. I think Kaushik, you can share that with us. Kaushik, you are there? Kaushik, can we hear the recent case what you shared with us? I don't know, some problem.
Yeah, Poonam, move on.
Yeah. So we have known about what is the criminal liability. So now let us focus on what is the corporate criminal liability. As Pravin sir has rightly said, it is the.
Kaushik, are you there?
Yeah, I was just connected.
Okay. So we were actually asking whether you can share that recent case law to the benefit of the audience.
Okay, I'll request my colleague, yes, Pooja to share. Pooja, please.
Okay.
Pooja is a qualified company secretary working with me.
Yeah, so there was a recent adjudication order passed wherein a public unlisted public company had used the term CEO for one of the managers, and he was signing as a CEO, but he was not officially appointed as a CEO by filing DIR 12. So so the adjudicating authority has imposed penalty for that in that case. So they have made it mandatory to file DIR 12 even if we are just using CEO, and CEO, the applicability of CEO is not applicable to the company.
Basic criteria is not applicable to appoint CEO, but since they are using the designation, adjudicating officer had imposed the penalty by issuing the order, and there was a heavy penalty to directors and company. So on this we need to deliberate, because there may be hundreds of companies, probably seniors can share their views. In that case, what is your views?
So I think it is part of the definition where somebody pretend himself to be CF or a CEO, then of course he's also liable. That's what I think.
Yeah, that is right. Absolutely, you are right, because you are making the public to believe that he is part and parcel of it. Because This is something called the indoor management. Because we do not know, really speaking, go to check whether you have passed an accessory resolution, you have the board minutes, you have this. There's none of our business. Our business is the moment the information comes from the company's letterhead, authentically signed by some person, we presume everything is actually in order in the company. So he is actually a CEO. He presumes he is duly appointed CEO. He has got the power. He is doing it. We believe it. So that means it is nothing but making the others to believe misleadingly and inducing the person to take a decision. So naturally, he is criminally liable on that. That is the principle on which this is working.
Yeah.
So it is a message to the corporate, na? They have to be cautious now on
Correct.
the basis of this case law, that either file DR12 or face the consequences, right?
Absolutely, you are right. Absolutely, you are right.
And Kaushik bhai, things are changing very fast. As I just read, last week, one judgment where, the promoters were giving information, positive information to the stock exchange that, company is growing, this, that, where company secretary was silent. And then, subsequently it was discovered that, it was a wrong information to the investor. So the company secretary, by not speaking also, he was penalized by 1 lakh. So that's also new things which are happening,
Okay.
So yeah.
So I think with this, through this platform, it's a message to all the participants and rest of who will listen the recording, that one has to be very careful on the basis of this case law and do the needful act to ensure that this doesn't apply, this order or the consequences does not applicable, and one has to either fulfill or remove such designation or change the designation, right, Mr. Bala?
Yeah, in fact, there has been actually what you call a circular issued long back. I think some of you all may not be knowing it because it was Atul may recollect it, or rather Pravin will recollect it. It was actually a Department of Company Affairs.
Director, functional director.
Yeah, no. Misleading designations. Because there are many companies, they used to designate director. Director HR, director finance, director this, director. They are not the board.
Functional director, who are not on the board of directors.
They are not on the board. There is no resolution. There is no form. Nothing. But they simply use the designation director.
Yes.
The long time back, the company, the Department of Company Affairs has actually issued this misleading direction should be actually avoided by the company secretary. By the company, they should not use the misleading direction, because that is giving a wrong message in the public. They believe they are part and parcel of the board. They are talking on behalf of the board of directors. That is what the circular has come long time back. Not only that, after that 2-3 times, there has been again re-emphasis of the circular has been also issued thereafter. But still there are companies which are actually doing it. What to do?
Yes,
because we are not taking in the right spirit. That is a whole issue.
Okay, thank you, Mr. Bala and Mr. Atul Mehta. Thank you.
Yeah, please. Yeah, Poonam, we can start. Yeah.
So the corporate criminal liabilities can be defined as a crime which is committed by the individual and the association of individual who acts which is forbidden by the law with the willful intention and guilty mind for the benefit of the corporation and the individuals. So when the corporate is held criminally liable, not only it affects the company but also the individuals who are associated with that company who is engaged in the criminal conduct. So that individual also suffer criminally and financially for the act which is done by the corporation.
Yeah, for the benefits of those participants, see this webinar we are going to be uploading into YouTube channel, So if you wanted to maybe it will be live in another 3 days. So if you wanted to forward it to your friends and the well-wisher, you can just forward them, because this is a very good deliberation, which many of us we are not probably understanding or taking it very lightly, either a chartered accountant or a company secretaries. Yeah, Poonam, continue.
So in Z Telefilms Limited versus Sahara India Corporation Limited, where the company was discharged from the liability arising after the defamation, where there was absence of mens rea, which is considered as an implicit requirement under the law. In case of Iridium versus Motorola, a different view was held where the Supreme Court held that the company could not be held liable for the statutory offences as well as the common law offences where there is a requirement of mens rea. So under this case, the Supreme Court was under the impression that the company is a separate legal entity, and that's why the company cannot be liable for the imprisonment.
I think in this Z case where I think Sahara India has filed a case against the Z Telefilm. Probably Z Telefilm must have shown something in their channel, something bad about the Sahara. And the Sahara has filed a case, corporate criminal liability, something like this. So, I mean, there is a very detailed judgment by the Supreme Court about the mens rea, and now people has to understand this. I just vaguely remember where the Sahara has filed a case against the Z Telefilm uh, for streaming something which was against the Sahara, and where the Supreme Court has laid down that look, it doesn't have any mens rea, and there is nothing to hurt, something like this. Yeah, Poonam.
There is somebody has asked the question. If the company has got 3 business divisions and 3 CEOs for the same, and 1 MD as the reporting boss, then is the company required to file DR12 for those 3 CEOs? Here the question is, if the 3 CEOs are not part and parcel of the board, then they need not file the DR12. But however, they are, by virtue of it, they are responsible because they are running the individual divisions. Okay. Naturally, if something goes on wrong on day-to-day affairs, etc., and other thing and all, they are actually responsible. The MD who is sitting in the other place may not be responsible, but overall responsibility lies with the MD. He has to ensure that these 3 people function and perform what is required to be done. That is the role here. Because you all will recall it, there was one of the landmark judgment which actually came in relation to the labor law case as back as 1994 or 1995. It was relating to the occupier of the company, who's really in charge if something goes wrong in the unit, because there used to be some 4 or 5 units those days used to be there, and the head office used to be somewhere in the central place. So something goes wrong in the 5 places, etc. Who's really responsible? That is the question. Although the MD is per se responsible, the law said very clearly the MD has to designate a person who's actually occupier of the factory. So that means naturally this CEO, what you are talking about, they are responsible here per se. That is the thing. The company has to take that stand. If the company still wants to make it, they are on the officer and default, still they can make it, still they can file a form also, although they are the non-board member, that also can be done. That is not the case. Yeah.
So there was that the company cannot be.
Samir, what you are saying? 2 contradictory judgment, one consider mens rea, other one does not.
Just now there was a slide explaining about the Z Telefilms and Sahara, and there was another case study regarding that. It talks about the mens rea. It gives for the first one doesn't give the preference to the mens rea, and other one it gives the preference to mens rea. So more or less 2 contradictory judgments, because mens rea in the first one it was absent, absolutely absent, and in other one the mens rea was there and it was considered. So how could it be 2 contradictory judgments? I don't understand exactly.
No, there is no contradictory judgment. See, as I said in the beginning, I gave you the example. My garden has been spoiled, whether it has happened accidental or it is done deliberate. That is what the law expects. Whether it is done with a guilty mind or whether it is happened accidentally or without any intention. If it is done deliberately with intention, with a guilty mind, mens rea, then yes, it is
sir,
criminal.
with all due respect, whatever you're talking about, it's quite similar to Ryland and Fletcher case, wherein which the strict liability has been explained in very thorough manner. So more or less, the liability which you're talking about, absolute liability, it's already it's an Indian kind of version where it's described in a oleum gas leak case by Mehta itself. So more or less, what I'm insisting over here, the mens rea has to be established. But in first case, there was an absence of mens rea. Then also, it's that the company was absolute discharge from the liability. And in the second case, the company made liable for that particular act itself. So here, doesn't it sound like the 2 contradictory judgments are there?
No. I think you are mistaken. In case of the Z Telefilm and the Sahara case, it is the statutory offences was established, which is in the nature. Mens rea was not there, as Atul Mehta was telling you. it is not done with the intention. It is not done with a guilty mind. That was absent in this case. So when the guilty mind is absent in this case, then it is not the criminal liability, but whatever the things have happened, that will go into the civil liability. So you have to distinguish between these two, whether it is the criminal or whether it is the civil. So there cannot be a contradictory judgment. If the guilty mind is established, yes, it is criminal. If the guilty mind is not established, yes, it is civil. But the thing is, liability is going to be there in both the cases. But the only thing is whether it is a fine, penalty, or it is going to be an imprisonment. That is the question. Yeah.
I think,
Yes,
you know,
sir. Yes, sir.
we can have a separate webinars for this. You know, I think this is a very interesting case. I agree with Samir. Yeah, we can have a separate webinar on this with an expert. Yeah. Poonam.
So the corporate criminal liability concept was established under the Companies Act, and the liability of the directors under the Act has been increased. Not only the directors, but also the officers in default are also liable, who has the information related to it or has participated to be the part of that Act without raising any objections. So now let's discuss about the sections in which the officers in default shall be liable for the imprisonment under the various activities. The first one is section 34, which talks about the criminal liability for misstatement in the prospectus. So if the company issues the prospectus which contains untrue or misleading statement in the form of inclusion or omission, thereby inducing another person to buy the shares on that faith, then the officers in default shall be punishable with the imprisonment, the term shall not be less than 6 months, but which may extend to 10 years.
Next.
The next one is section 57, punishment for personation of shareholder, where the person deceitfully personate as an owner of any security and receives any money due to such ownership, then that person shall be punishable for the imprisonment. The term shall not be less than 1 year, but which may extend to 3 years. The next one is section 58, refusal of registration and appeal against the refusal. If the company refuses to register the transfer or the transmission of the security within the time specified under the Act, and the person contravenes the order of the tribunal, then the imprisonment term, which shall not be less than 1 year and which may extend to 3 years. Next is section 74, which is regarding the repayment of deposits. So if the company fails to repay the deposits or the interest, then the officers in default shall be liable for the imprisonment, which may extend to 7 years. The next one is section 76A for the contravention of the provisions under section 73 and section 76. So imprisonment shall be for the term which may extend to 7 years. Yeah. So the next one is section 118. So it talks about the manner in which the minutes should be kept by the company. So if after the minutes are kept in the book, if any person is found guilty of tampering that minutes of the proceedings of the meeting, then that person shall be punishable with imprisonment. The term shall be the term of the imprisonment may extend to 2 years.
Here we come actually, here our drafting skill and actually translating what is really transferred in the board meeting, that has to actually find a place very, very carefully. If something goes wrong here, then definitely, no doubt, we are the custodian of the minutes and all the company secretaries will invariably be liable. And second thing is, wherever the secretarial audit is applicable, then if anything is there in the minutes, because he is supposed to inspect the minutes, based on the minutes inspection, he is supposed to certify the secretarial auditor's report. So if something goes wrong, equally the professional who is actually a secretarial auditor, he will be also liable in this particular case. So we have to take utmost care here. Because I have come across the cases in the past. Company has actually mentioned in the preamble of the resolution, they are considering the appointment of independent director. But where the resolution is actually appointment of the additional director. On the very same issue, the regulator has actually issued the criminal notice, both the person who is the company secretary in the company, the person who's actually certified the DR 12, he actually started taking a plea. Although the resolution was actually produced to me, I had gone through as certified. He said, no, you are supposed to see the minutes. You are supposed to see the minutes entirely. You are supposed to understand the minutes. You have to see what is it, what is the intention. Have you done that? That is the case which is actually going on. So we have to be very, very careful when we are talking about the drafting of the minutes. Yeah.
The next one is section 127, the punishment for failure to distribute the dividends within the prescribed time. Then the imprisonment shall be extended to 2 years. The next one is the section 129, which talks about the financial statement should be in the prescribed form. The financial statement gives the true and fair view of the state of affairs of the company. So if the company contravenes the provisions under this act, then the KMP shall be punishable under the for the term which may extend to 1 year.
Not only that, equally, the auditors, statutory auditors, where they're certifying, they are also equally liable. I think Pravin can add to this. Yeah.
Sir, you know that the Schedule 3 has undergone a lot of changes.
Yeah.
And I found that a number of companies could not present their financial as per the amended Schedule 3. And I think this section would teach them a lesson and to follow it religiously, actually.
That is true.
The next one is section 182. So it talks about the prohibitions and the restrictions regarding the political contributions. A company other than the government company and the company which has in existence for less than 3 financial years can contribute any amount to the political party by resolution passed by the board of directors at the meeting. And such contribution amount should also be reflected in the profit and loss account of that company. So if the company contravenes the provisions of section 182, then the imprisonment term may extend to 6 months. The next one is section 185, loan to directors. So if the company contravenes the provisions mentioned under section 185, then the term of imprisonment may extend to 6 months. The next one is section 186, which talks about the loans and investment given and securities provided by the company. So under this provision, the imprisonment term may extend to 2 years. The next one is section 207, which talks about the conduct of inspection and the inquiry. So if the director or the officers of the company disobeys the directions issued by the registrar or the inspector, then the term of the imprisonment may extend to 1 year. The next one is section 217, the procedures and the powers of the inspector. So if there are any director or the officers of the company disobeys the directions, then the imprisonment term may extend to 1 year. The next one is section 221, which talks about freezing of the assets of the company on inquiry and the investigation. So in case of any removal, transfer or disposal of the funds, assets and property of the company in contravention of the order of the tribunal, then the imprisonment term may extend to 3 years. The next is section 222, imposition of restrictions upon securities. So if the securities of the company are issued or transferred or act in the contravention of an order passed by the tribunal, then the imprisonment term may extend to 6 months. The next is section 86, punishment for contravention of provisions related to registration of charge. So if the company contravenes the provisions of all the sections regarding the charges, then that person shall be liable for the imprisonment under section 447, which we will cover in the next slide. Under section 229, penalty for false statement and the destruction of documents. So under this section also, the person shall be liable for action under section 447. Section 245, that is the class actions. If the company obeys the order passed by the tribunal under the application made by the member depositors or the classes of them, then the imprisonment term shall extend to 3 years. The next one is section 274 for the directions for the filing statement of affairs. So in this, if there is a contravention of the provisions under this section, the term of the imprisonment may extend to 6 months. Section 337, the penalty for the frauds by the officer. Under this section, there is a mention about the penalty for the fraud done by the officer. So the term of the imprisonment was not less than 1 year. Section 338, liability where the proper accounts are not kept by the company. So in this case, the imprisonment term shall not be less than 1 year. Section 447, penalty for fraud. So without a prejudice to any liability, if including the repayment of any debt under this act or any other law, the person who is found to be guilty of fraud involving the amount of at least 10 lakhs or 1% of the turnover, whichever is lower, then the imprisonment term shall not be less than 6 months. And if the fraud in the questions involves the public interest, then the term shall not be less than 3 years. And if the fraud involves the amount less than 1 lakh or 1% of the turnover of the company, whichever is low and does not involve the public interest, then the term of the punishment shall extend to 5 years. The next is section 448, that is the punishment for the false statement. So if any report, financial statement, return, prospectus, filing, etc. were made false or omitted any material fact despite of having the knowledge of that, then the person shall be imprisonment under the section 447. Section 449, that is the punishment for the false evidence. If the person intentionally gives any false evidence, then in that case, the imprisonment term shall not be less than 3 years, but which may extend to 7 years. The next one is section 452, which is the punishment for wrongful withholding of the property. So if any person is wrongfully withholding the property which is not belonging to him, then the imprisonment term will extend to 2 years.
In this case, there have been cases in the past where the company officer is actually resigned from the company or his services have been terminated, whatever the things are there. His full and final settlement is actually not done by the company for some reason or something, etc. He had the company's property with him, say laptop, motorcycle, something, etc. like that. He is supposed to actually hand over this back to them. Not only that, even if he is living in a rental accommodation provided by the company, leased accommodation, he is supposed to vacate and give, because the separation of services happen, whatever the means it is. But in any of the cases, if he has not handed over the things back, notwithstanding to the full and final settlement is pending for whatever reason it is, still wrongfully withholding the property, the criminal action can be taken against the person can be sent to jail. This is one issue is there definitely, because many people think, oh, they are not settled full and final settlement, I won't return the money, I won't return the property. That is a wrong approach, because I personally dealt with this sort of the cases. Person was really arrested. In spite of my advising him, he did not listen. But ultimately, getting out of the things was a nightmare. So people have to take note of it, because although it says only wrongfully withholding, etc., it will happen in our day-to-day life also if we are behaving like that. Yeah.
No, actually, I am appreciating the example given by Balaji actually, and we come across a situation in day-to-day matters actually, and we see such cases. And really, your example would help us to advise the directors.
Yeah. Yes, Poonam.
Yeah, the next is decriminalization of the various offenses under the Companies Act 2013. So the Company Law Committee has decriminalized certain sections under the Companies Act 2013 to make the good offenses. So the committee was set up by the MCA under the Companies Act 2013 on 13th July 2018, which has submitted its report on August 2018. And the report allowed for in-house adjudication of the offense that are caused due to the technical lapses. Companies Amendment Act 2019 has received the assent of the President on 31st July 2019. And the report has further effected by amendments in various sections under the Companies Act 2013. Further, the Company Law Committee was set up by the MCA on September 2019. Under this, on the basis of the report submitted by the committee, the MCA has introduced Companies Amendment Bill 2020, which was passed by the Lok Sabha and Rajya Sabha in the year 2020. And the Companies Amendment Bill 2020 was enforced by the Companies Act 2013. The main aspect for the decriminalization of the various offenses was recategorizing of offenses from compoundable offenses, removing the imprisonment under the particular sections and subjecting the offenses to be fine alone. So only the fine was imposed in place of the imprisonment under some certain sections. And the next is reduction in the penalty under the listed sections. The next is provision of alternate mechanism for the offenses and the removal of penal provisions from the particular sections. The next is recategorizing of the offenses from the compoundable offense. So compounding is a settlement mechanism by which the offender is given an option to pay money in lieu of his prosecutions. So section 441 of the Act provides for the provisions pertaining to the compounding of an offense. So under section 441, the following offenses can be compounded. So offenses which are punishable with only fine, the offenses which are punishable with fine or with imprisonment, and the offenses which are punishable with fine or with imprisonment or with both.
Which means offenses punishable with imprisonment can never be compounded.
Yes.
That is the bottom of the case. Yeah.
The introduction of the in-house adjudication mechanism introduced along with the compounding. The provision of this mechanism provides under section 454, under which the adjudicating officer has the power to settle the offenses by charging the penalty as deemed fit from the defaulting companies and the officers in default. The order of the assessing officer appealable to the regional director of the MCA. Authority for compounding under the Companies Act 2013. The regional director has the authority to compound the particular case if the amount of fine for an offense is up to the 25 lakhs, and if the amount is exceeding the 25 lakhs, then the NCLT has the authority. So these are the some sections under which the imprisonment was removed. This is section 8, which talks about formation of the companies with charitable object. 26 regarding matters to be stated in the prospectus, securities to be dealt with the stock exchange, variation of shareholders' right, prohibition on issue of shares, rectification of register of members, and few others. So under this section, now only the fine was imposed on the company and the officers in default, and imprisonment term has been removed from the all these sections.
Poonam, Samir is asking why it is called the in-house.
Sorry?
Compounding matter you are talking now.
Yeah.
So Samir is asking why it is called the in-house.
In terms.
In-house. Adjudication order.
I don't know what is he saying, but yeah, it can be more clear.
The significance of this word, why is it called in-house? Because had it been, it has to be adjudicated. If it has the criminal liability, it has to be adjudicated by the adjudicating officer. The assessing officer has to be adjudicated. But why is it called in-house? That probably that the other panelist called the sir understood that my significance of the particular word. Thank you.
No. I'll tell you what is it. ROC is actually the person who's a designated person who look into the company's affairs, etc., and other things and all. And when the non-compliances happen, earlier it was said that he will actually send a report to the regional director and he will take a call, he will do it. Now what happens here, it is actually said the ROC himself is appointed as an adjudicating officer. He is empowered to issue the show cause notices, etc. He can act as an adjudicating officer on these cases. He can decide the cases. That means without involving other judicial authority, he can impose. However, that order, adjudication order, is also applicable. So because he was earlier not the adjudicating officer, now he has been brought. The person who's actually made the records of the MCA, etc., has been brought into the picture. This is actually termed as a in-house. Otherwise, there is nothing. Yeah.
Yes, sir. Now,
If you see very recently, there are a lot of adjudication order has been passed by the ROC.
So there is no as such adjudication officer there.
Yeah.
There is no as such.
Yeah, now there is a circular has been issued by MCA saying that the ROC has been appointed as adjudication officer. I think a circular has been issued to that MCA separately. In fact, if you see any of the adjudication order, the very first part will start actually appointment of the adjudication officer. He will write there by virtue of in excess of power so and so so and so. I have been appointed as adjudication officer. That is where it starts actually. That is why it is the in-house. Yeah. Go ahead, Poonam.
This is the one case, Puneet Arora versus the ROC, where the prosecution was filed by the regional director against the managing director, company secretary, whole-time directors, and the directors. Upon the inspection caused by the ROC, the ROC has found that the non-disclosure of capitalization of borrowing cost in the balance sheet in the year 2010, 2011, and 2012, and non-disclosure of certain class of assets in the balance sheet of the company for this 3 financial year. And they have called upon the clarification, but the ROC was not satisfied with, the regional director was not satisfied with the clarification, and they have directed the ROC to launch the prosecution against the company. So prosecution was initiated against the MD, CS, WTD, and the directors. So they have filed the case against the Supreme Court. So Supreme Court has held that after hearing from both the sides, the Honorable High Court, Delhi High Court concluded that the case was hopelessly barred by the limitation. Further, there is no provision under the Act whereby any consent of the central government is required for prosecution of the offences under the Section 211 of the Companies Act. This is the 1956. Hence, the High Court has issued quashing of the complaint filed by the ROC or other proceedings against the company and its officers. So the company secretary and organization could understand the law and its interpretation and the act according in the best interest of the company, taking into account consideration of the provisions of the law and also the judgment pronounced by the various court.
See here, the question arises, yeah, really there is an offense has been actually committed. When the offense has been committed, then the action against the committed offense is taken by the regulated what period of time? Can they take any time? Can they take the proceeding after 1 year, 2 year, 3 year, 4 year, 5 years, 6 years? This is the question which actually comes here. Because what happens there is we have a bar of limitation act. The bar of limitation act, if you are all aware, suppose I borrowed a money from Atul. Atul has given me, he was kind enough to give me 1 lakh rupees money. I borrowed from him. But I am not dealing with him on a regular basis. I told him, okay, 1 lakh rupees, you give it to me, I will pay with the interest so much. That's all. I say that. I also don't pay, Atul also forgot. Now 3 years have passed. Suddenly Atul remembers and tells me, Bala, I gave you 1 lakh rupees, you are supposed to make a payment. Why don't you make a payment? I just look at it. It is 3 years have already passed. He has never reminded me in the last 3 years. Atul, definitely I know I am supposed to pay 1 lakh rupees. But it is already 3 years has passed. Legally, I am not supposed to pay. But he doesn't want to leave. He takes to the court, and the court comes. Then they go into the detail. Then I plead. Although I agree, there is an offense is there. I am supposed to repay. But the thing is, he has not taken any action. I have not repaid for the last 3 years. It is hit by the limitation act. Legally, I am not bound to pay. Court dismisses the case. I am not bound to pay. So that means the same case here, it is hit by the limitation. Because if Atul would have taken the case, within 3 years' time, he would have got the money. Because he has extended beyond 3 years' time, it was actually that it is a interpretation of the law again, which comes, I said in the very beginning only. So many cases it happens, the regulator delays the action. Yes, there are gateways to get along with this, where the company secretary is, diligent enough to find out where it is there. I also dealt some of these cases. It is hit by limitation of the act. That is there. So this is what exactly is happening here. The regulator has taken much beyond the limitation period. So they are able to get away. They got the criminal complaint cost. Yeah.
The next one is for the Shiv Kumar Jatia versus the state of NCLT of Delhi. Under this, the Shiv Kumar Jatia was found guilty, but he is actually not. So under this case, the guest of Hyatt Regency fall from the terrace. So the managing director was prosecuted for with the claim that the no proper safety measures were taken care by the managing director, whereas the managing director was not present in the country on the day of the incidents. So under this case, the Supreme Court had stated that an individual being a director, managing director, or the chairman of the company can be made an accused only if there is a sufficient material to prove his active role coupled with the criminal intent, and the criminal intent must have a direct nexus with the accused. Thus, while setting aside the order passed by the Delhi High Court in relation to the criminal liability of the managing director, the Supreme Court stated that the allegation made against the managing director is vague in nature, and this constitutes a ground for causing the proceedings under the Criminal Procedure Act.
I will actually come back to Samir. I think
Okay, so you can't make
somebody raised the question. If there are 3 division, 3 CEOs are appointed, managing director is there, whether he can be held responsible. More or less, this is similar circumstances like that. Here, I remember this case. This case is actually a hotel which was run at the Delhi Hyatt Residency. And in fact, there was an in charge who was there, actually was looking after the day-to-day affair. They had a terrace. The terrace was actually marked for a smoking zone, actually. It was late at night. Some gentleman who was there, he wanted to go to the terrace. The person who was there actually in charge, he told him, do not go to this terrace at this particular hours because it is dangerous. It is sufficiently not lighted and it is very late hours, etc. and other thing and all. Do not go. In fact, there was other place was there, he was directed, but the person did not listen to him. In spite of his warning, he actually went to the terrace. The unfortunate incident has taken place. Ultimately, the in charge is only managing director. The case has been filed against the managing director who was out of the country. He was not at all present. He was not even aware what has actually happened. But of course, the lower court has actually held him guilty. He is responsible for that. And against that, he appealed for the Supreme Court. After interviewing the Supreme Court said actually, there is nothing to say he is directly involved and his negligence, etc. has been attributable to this particular incident. That hotel has taken enough steps to prevent the person even advising him not to go. But in spite of that, he is actually disabled. He has done like that. So if at all anybody can be held responsible if the day-to-day affair who's running the affairs, if he has not taken the thing, it is not that. So on that ground, the managing director was actually acquitted in this particular case. So really question arises here, is direct involvement and how much is attributable, whether they have acted in negligence. These are all the things will actually come to the picture when we are examining the case. That is the case here. Yeah.
So since the Companies Act has increased the liabilities on the directors and the officers in default, the directors and the officers in default has to find some safeguards. So these are director and the officers can mitigate the risk of personal liability. Liability through various safeguards is like they can insist the company to include the clauses in the shareholder agreement or the employment agreement regarding the indemnification of the clause. Directors in the case.
This is very important slide. I think all of us, we should understand and note this. If you're an employee company secretary, you should have this kind of a precautions and measure. Yeah.
Absolutely right.
So,
yeah, Pooja.
Directors and the KMPs to safeguard themselves in case of any claims arising from any third party due to their bona fide actions in the company. The person can also insist the company to obtain the director and the officers policy insurance in the company.
In fact, D&O insurance is catching up nowadays because in case of the 1,000 top listed companies, they are actually mandatorily required to have the D&O insurance. Obviously, D&O insurance covers the company secretary as well. So probably this will be the increasing trend to take care of to some extent. Yeah.
Yeah. So, and also at the time of the board meeting, if the director is dissenting from any activity or the business, on which they feel that it is violative, and they violative, then at the time of preparing the minutes, the director should keep in mind that their dissent must be recorded in the minutes, which can be useful for him in the future.
This is very important because anything concerning to the non-executive directors, independent director who is also a non-executive director, it is very important for them because they are not involved in the day-to-day operation. They are actually involved only through the board processes. In the board processes, they cannot be a silent spectator. If they have certain reservation, if they have certain dissent, they have to get it rejected, get it written there actually. And other thing is there, if you actually see the Companies Act as well as the secretary standard which is issued by the institute, very categorically says the draft minutes are required to be circulated within 15 days from the date of the board meeting. So invariably it goes all the directors, including non-executive director, independent director, everybody, irrespective of whether he is attended the meeting, not attended the meeting. So in such a case, he has got the option to see the correct minutes, whether he has got the option to see whether his dissent, his expression, etc. has been properly recorded or recorded. He has got another 7 days time to revert back and get the minutes corrected to that extent. So this care, the non-executive and the independent directors are required to take. That is there. Yeah. This will greatly safeguard their interest when it comes to them. Because actually Pravin was telling, there is a music faced by all the directors, left and right. MCA issues the show cause notice by going through the MCA list. They can't distinguish non-executive director and the executive director. Everybody gets a notice. So in such cases, this will actually come to the handy for prove themselves that they are not involved in day-to-day operations. Yeah.
So these are the coverages under the D&O policy. So the D&O policy covers the losses or the damages that may incur due to the actions mistakenly taken in the individual capacity as director and the officers under the memorandum and the article of associations. Any losses or the damages that may arise due to the claim against the directors and the officers for any wrongful act done in their official capacity. Any legal expenditures which arising out of the prosecution of the directors or the officers at the time of any investigation, then any expenses incurred by the shareholder in pursuance of a claim against the director and the officers, and the indemnity to the legal heirs or the legal representatives of the directors and the officers if the director and officers becomes insolvent.
There is one question has actually come here. It says, what about the liabilities of the KMP in other regulations like Income Tax, GST, Indian Stamp Act, Anti-Bribery, PMLA, Competition Act, whether defense of acting in divisions not counting, etc. are available under all these regulations? Yes, definitely it is available in all these regulations also. So all the things what we have discussed in the Companies Act, it is available in each of the act actually. If they act bona fide, if they act diligent, if they act without a bona fide intention, yes, it is available in the other acts also. And one more question has actually come. In iPad meeting these days, where is independent director notes saved? In whose servers? Whether independent director will have the access to his own notes for his defense, especially when it's saved with the company server as company property. Atul?
Yeah. Hello.
Yeah.
Yes, sir.
He is asking this question. In iPad meeting these days, where is the independent director notes saved? In whose server? Whether independent director will have the access to his own notes for his defense, especially when it's saved with the company server as a company property.
So nowadays, there are many companies in the market which provides this board solution, where all your notice agendas they've been stored in some software, where in iPad you can access this, you can make a notes, you can do many other things also, noting and all, and this gets saved. Normally, all the companies, good company, instead of storing in the IT company's storage, they store in their server. So all this notings and everything are available at the company's server. So what was the question here?
Question is, in iPad meeting these days, where is the independent directors notes saved? So that means it is the
It is
company's
normally,
normally it is
normally,
the,
so yeah, because these are all very confidential, and they do not want any IT companies, the outside vendor, to have a knowledge about it. Particularly company like Reliance or Grasim and all, So if they are using outside software, companies platform, so it has to be normally 99% companies they store in their own storage.
Yeah,
sir,
yeah. In continuation to the
whether
same,
yeah,
sir. You can continue the second part of the question. That is fine.
yeah, whether independent director will have access to his own notes for his defense, especially when it is saved with a company server as company property. The
Of
question
course,
is,
if I'm an independent directors in a company and I'm using that software for the board meeting, and tomorrow if I have to retrieve, last year minutes where I've done my notings and all, the company should give them access. If the company is not giving an access because of some reason the data has been deleted, this and that, of course, that's altogether a different case. But if there is a malafide intentions for not providing, then of course it has to go on a case-to-case basis.
yeah, because they cannot actually deny because the minutes are permanent records. There is no question of delaying or something like that. It has to be customize the items, or it is a standard product of their own. DNO insurance.
I think,
See,
yeah, Mr.
DNO insurance. Yeah. Yes, Atul.
Mr. Pravin wanted to say something.
Yeah, I would like to reply this question actually. Tata Ag is one of the insurance companies which is a leader in the providing D&O policies actually, and they cover the defense cost also besides the cost imposed by these authorities, and they reimburse the defense cost in advance of the delivery of the final judgment. Tusharji can look for the other companies also, but Tata Ag is one of the leaders in providing D&O policies.
It is also applicable to that legal heirs and legal representatives.
No, they cover the defense cost plus the penalties or fines going to be levied upon you.
I mean to say indemnifications for the legal heirs. Suppose if I may not be there, in that case, any claim or any penalty will be there on me. So are they extended to our legal heirs also?
I think legal heirs would not be subject to the penalties by the authorities actually.
Yeah,
because the crime has been committed by the person, the KMP only. KMP would be liable for all these things.
Agreed, but suppose if it is a monetary policy, so can it be extended to my legal heirs?
No.
Legal hair will not be covered definitely here because one thing is there. There are two issues. One is the criminal liability, one is the civil liability. In case of the criminal liability, it is actually relating to a person. So in which case legal hair is definitely not involved. In case of the civil liability, when you take monetary issues, etc., and other things are all there. In such a case, probably the estate which belongs to the person, if the legal heir is actually enjoying the succession of this property, then the monetary thing can be recovered from the legal heirs. That is there. And again, somebody asked the question, whether this D&O insurance will be standalone, standardized one, or it is a customized one. So if you are paying a thing at that particular time, you have to get it customized to your request. If you actually get it customized to your request, yes, to that extent, yes, so long as the estate belonging to the person who's liable, to that extent, yes, it can extend. But you have to get it customized your D&O insurance.
Okay, so suppose if I'm having a 7 directors, 1 CFO and 1 company secretary, so to the extent of my civil liability, suppose if the regulator has imposed a penalty of 10 lakh rupees each, like so out of 70 lakhs, like suppose if I may not be there in future, so in that case that 10 lakh rupees can be needs to collect it from my legal heirs, from my own asset.
Yeah, so long as your legal layer is actually going to pay this money on your behalf, since you are covered under the DNO insurance, yes, to that extent, yes, it will go.
Okay. Okay. Thank you.
Yeah.
Yes, yes,
Poonam.
Poonam.
Yeah. Poonam.
So as we all knows that the independent director and the non-executive directors are not associated, not involved in the day-to-day compliances of the company, then they cannot be held liable for the actions taken by the other directors which are in the day-to-day operations of the company. So MCA has come with the circular by dated 2nd March 2020, in which the circular the ROC has clarified that MCA has clarified that the ROC are required to follow standard operating procedure as prescribed by the MCA while initiating proceedings against the officers who is in default to safeguard the interest of the independent director and non-executive director. The circular was circulated by the MCA.
This is the very latest thing which has come from the MCA, recognizing the role of the non-executive director and the independent director. So probably I think as Pravin was telling, left and right, they are issuing notices to everybody. So at least to that extent, this will help to the people in getting reduced the notices to at least the non-executive directors. This was the latest development which has taken place. Yeah.
So as a KMP, the KMP has a huge responsibility for complying the various provisions of the Companies Act while dealing with the matters, and the failure of which may abide by the provisions of the Act can lead to a huge penalties to the company as well as to the individual, means KMP also. Therefore, the KMP must be careful while dealing with the affairs of the company and must ensure that the maximum amount of transparencies are shown in their actions.
Great, Poonam. Very good presentation you have given in the very capsule form. You have covered in capsule form to the greater extent what is the criminal liability, how it is arising, who are responsible. Even you have given a case laws also and other thing. I am definitely sure our delegates would have got really benefited out of this particular seminar. My sincere thanks to you for nicely presenting the things very lucid language. Thanks a lot. Thanks for Pravin for your input. Thanks for your help also.
Sir, I would like to add one thing.
Yeah. Yes, please.
Actually, I would like to supplement Poonam regarding section 463 of the Companies Act.
Yeah.
Sorry.
That provides relief in the proceeding for negligence, default or breach of trust against an officer of a company. If it appears to the court hearing the case that he is or may be liable in respect of negligence, default, or that having regard to all of the circumstances of the case, but that he has acted honestly and reasonably, and that having regard to all the circumstances of the case, he ought to be excused, the court may relieve him either wholly or partly on such terms as it may think fit. At the same time, that section provides that where any such officer has reason to apprehend that any proceedings will or might be brought against him in respect of negligence, default, or breach of duty, misfeasance, or breach of trust, he may apply to the High Court for relief, and High Court on such application shall have same powers to relieve him as it would have had it had been a court where which the proceedings for negligence, default has been brought. So that is I think, relief to the KMPs.
Yeah.
463 provides for their protection from the such liability which has come or which is likely to come.
But one more thing is there. In case of the, encouraging the startup companies, the small companies, medium companies, etc., the company law recognizes the small companies. In case of the small companies, the fine penalty, whatever is applicable, is reduced to the extent of 50%. Because we're leaving the fine penalty, etc., they will actually examine whether this company falls under the ambit of the small company. If it is a small company, it is only the 50% of the fine and penalty is actually charged. There is another relief which is given by the regulators.
Yeah, great, sir. Thank you, Pravin Bhai, for your wonderful support. And in a very short notice, you also accepted our invitations to be a part.
In fact, there are a lot of people are appreciating excellent presentations, attempt to cover all the facts and subject in the lucid manner. Entire seminar was actually informative and raised many questions in the mind of the CS. It will always be difficult to work with the listed company. nice knowledge sharing. Very good presentation. Thanks you all.
So
Definitely
this recording of this webinar will be available on our YouTube channel. So please subscribe to our channel so that you'll get those regular alerts also. And yeah, thanks once again. This is, if you have any suggestion for any topic, please let us know so that we'll cover it up in the forthcoming programs. And yeah, it's more of a knowledge sharing and more of a deliberation. Thank you all. Thank you all. This gives a lot of encouragement to us to come with new topics and new new faculties on this platform. So you see those the faculties are always a new one. So thank you. Thanks to all everybody. Thank you. Thank you, Mr. Bala.
Thanks
Thank
a
you,
lot to
Poonam.
everyone. Thanks to Pravin. Thanks Poonam. Thanks to all the delegates. Thanks a lot.
Thank you. Thank
Have
you.
a good weekend.
Thank you. Yeah. Thank you, Poonam.